Hello. We're going to be speaking about procedures followed in the Superior Court. I'm Temp Smith, 32-year practitioner from Allegheny County and candidate for the Superior Court. Today we're going to be speaking about commencing appeals in the court, the basis upon which appeals can be brought, procedures in the Superior Court, and how appeals are taken from the Superior Court. Commencing an appeal in the Superior Court is a simple act. Basically, you file what is known as a notice of appeal in the Court of Common Pleas, in the trial court. Notice of appeal is a one-page document basically telling the court that you're appealing. Now, in order to appeal from an order, the order must be a final and appealable order. And what's meant by that is that the order must decide all issues in the case with regard to all parties to the case. If it decides less than all issues or leaves parties out, then it is not appealable. Now, the basis upon which an order can be appealed are two. Either the court abused its discretion, and what's meant by that is that the judge may have ignored evidence or just otherwise acted in some improper manner, not strictly based on law, but just improperly. Or the court may have committed an error of law. For example, the court may have allowed evidence to come before the jury that the jury shouldn't have heard, or the court may have wrongfully instructed the jury as to the law to apply to the case. Now, once the case is in the Superior Court, there are certain procedures that are followed that are prescribed by the court's rules. Generally, this is an error-correcting court, and the Superior Court does not hear evidence, does not hear testimony or look at documents other than documents that were looked in the court below. It bases its decision on the record from the court below, and it bases its decision on the briefs and arguments of the parties. Now, their briefing schedule is set out, and I have to say the briefs are sometimes anything but brief. But aside from that misnomer, what happens is the appellant is given a chance to present the appellant's argument in a brief, then the appellee is given a chance to respond, and the appellant gets the last word in a reply brief. Then, court schedules oral argument. Oral argument is where each side is given 15 minutes to present its case to the court. Now, the Superior Court is what's known as a hot court, and what's meant by that is that when you get to oral argument, you'll find that the court has already read the briefs and read the cases that are cited in the briefs and knows what the case is about and just has particular questions about some aspect of it. Occasionally, the court will dispense with argument altogether, but in most cases, argument is held and you get a chance to emphasize the important points in your argument. After oral argument, the court considers the briefs and the argument and renders a decision, usually in about 3 to 4 months. And if their decisions are of two sorts. Generally, there are either reported decisions, which means these decisions go into the law books and into the internet resources so that other lawyers can look at them and use them in connection with their Superior Court briefs. Or they issue what is known as a memorandum opinion, and those are opinions that are just for your case and cannot be cited in another case. Now, if an appellant is not satisfied, or an appellee is not satisfied with the decision of the Superior Court, that person or corporation or whatever can take an appeal to the Supreme Court. However, the Supreme Court, unlike the Superior Court, does not hear all appeals taken to it. It only hears appeals by permission. You have to apply for permission to appeal to the Supreme Court. And it only takes fewer than 1 in 20 cases. These have to be cases of public importance or cases where the Superior Court's decision contradicted one of its own decisions or contradicted a Supreme Court decision or contradicted a decision of the other appellate court, the Commonwealth Court, or, as I say, matters of immediate public importance. In those cases, the Supreme Court will hear the case. Otherwise, the Superior Court is the court of last resort. I hope you've enjoyed this lecture. and will take time to listen to the other lectures in this series about the Superior Court.